So, Brooklyn, why don't we get started with mediation negotiations? We have an accident, and now where do we stand?
So before you would get to a mediation setting, there would have been some type of a claim filed. Normally, your typical accident cases are motor vehicles or a slip and fall, if you will, to where a claim was filed immediately after. And then after that claim was filed, you try to work with what we call adjusters who handles claims, and they try to look at what happened, look at the police report, gather your recorded statement. And for some reason, maybe you didn't get the desired outcome in that. Maybe they felt like they weren't at fault, um, and you don't agree with them. In that event, sometimes, oftentimes people go it alone, or they hire an attorney to help try to settle that, what we call that claim. And this is all pre-suit. And then you get to the point where if you hire that attorney then looks at the elements that are in play here with regard to a personal injury claim and those elements of negligence. And that rule typically involves proving four elements of the law, and that is your duty of care, whether the defendant owed a legal duty to the plaintiff or the claimant, what we call them. Then you look at the second element, which is a breach of that duty, and that is whether or not the defendant breached that duty by acting or failing to act in a certain way. And then you have that third element, which is causation. You also will hear proximate cause, but the blanket term is causation, in that you have two types of causations that it breaks down to. It has some tentacles to that element. You have what's called actual causation, which means that the harm wouldn't have occurred but for the defendant's actions or that adverse driver's actions. Like I wouldn't have been rear-ended but for the adverse driver not paying attention, following too closely, and eventually rear-ending me. And then you have something that's called proximate cause. And that is also a legal term where it's saying the harm was foreseeable. It was a foreseeable result of the breach, which was that element two, meaning you could foresee someone being rear-ended in a certain set of circumstances. And then you have what's called damages. And damages is, what did the plaintiff suffer in terms of harm? Was it physical? Was it emotional? Financial?
Yeah, a lot of times we hear people say that, oh, the law is broken or there's a problem with the system. And as you so eloquently put it, is really in the hands of people.